Hi and welcome. I'm here with Donnie Coates, who's a licensed probate attorney in California, and I'm Matt Dana, the founder of Jet Probate. Donnie, I want to ask you a couple questions that we get all the time on the phone, and probably the basic question, I think a lot of people have been told by somebody, either the title company or the bank, that they have to go through this thing called probate. And I think the public really doesn't understand what this thing of probate really is. What would be a kind of a simple layman's explanation of what is this probate process?
The probate process in California it's got a lot of administrative steps. There are formalities involved, third parties that are appointed by the court to assess value for the assets of the estate.
They don't just take a regular appraisal. They have to have some third party by the court come in there and approve that valuation?
Correct, yeah. There are certain assets that you as the petitioner can go ahead and provide the court values of those assets, but with respect to other assets like real property, for example.
Like your house?
Correct. You would actually have to go out and utilize a court-appointed probate examiner to give a valuation of that asset.
Now I know, Donnie, you're licensed in multiple states, including Arizona and Colorado and California, and you do probates in both states. How would you compare the probate process in California as to some of these other states?
I mean, with all due respect, California has a lot of hoops to jump through.
Yeah.
You certainly have the right and ability to go do a probate on your own. I wouldn't advise it. I think having the guidance of an attorney who deals with probates would make a lot of sense, because the process in California is really just because of the court's backlog. You're probably talking about 10 to 12 months anyway for the probate process. But if you make mistakes along the way, you're going to have 2 and 3 and 4 month delays.
Yeah.
To add on top of that time frame, and it could become a very long process.
Yeah, and we get that question all the time: is do I really need to hire a lawyer to go through probate? And the answer is, my old war dog answer is, I don't need to hire a dentist to pull out this tooth, but
right.
Probably a pretty good idea. How would you answer that? Do I need a lawyer in California?
I think the probate process could feel like pulling your tooth if you didn't hire a lawyer. So
yeah, well, and I also tell our viewers that it's not one of these cases where you start the probate process and then you stumble your toe and that tooth starts to ache and you come in and see us and say, hey, help me out. It actually would take us more time and be more expensive to try to correct some of the things they've done.
Depending on some of the actions and directions that a pro per person can put on a probate, yeah, it could become a big hole to dig out of.
Pro per meaning they're representing themselves.
Correct.
Yeah, and Donnie, back to this process, administrative hoops. I mean, isn't probate really the process of trying to take something that was in a decedent's name and transfer the title over to some survivors? But before the court's willing to do that, you got to go through all these administrative hoops. And tell us some of those other administrative hoops you got to jump through.
So in addition to actually filing your petition with the court, you actually have to publish notice so that you get 4 months for creditors to make claims on the estate.
So you have a chance for all the neighbors next door to come forward and say, I loaned the guy my lawnmower and he never brought it back, so I want to make a claim against the estate. And so you got to give notice to known creditors and publish to unknown creditors. That's a hoop. What about taxing authorities, and what kind of hoops you have to go through there from the state of California from an income tax standpoint?
So California, you do have to report to the Franchise Tax Board.
Yeah.
And that's to determine whether or not the decedent and or the estate have any taxes due.
They want to make sure before they pass, these assets down to junior, that we don't have to take something out for California.
Yep, California gets its bite at the apple. And then of course you still have to do your income tax reporting for the estate to the IRS.
Yeah.
And so there are formalities that are involved, and the process as a whole, you're always doing something over that 12-month period. And that's the most efficient of probates, in my opinion.
What about court appearances? Are they required in California?
They are. You have to have a court appearance for that initial appointment, and then you have a court hearing to actually close the administration of the estate.
So there's 2 required hearings before a probate judge, and then there could be other hearings in between if somebody comes forward to dispute a creditor claim, or somebody comes forward to dispute the validity of the will, or these other processes, right?
Yeah, I mean, 2 is the minimum, and it could be more depending on what plays out throughout that administration.
Yeah, that's one thing that's I know is a huge difference between California and Arizona. You know, in Arizona, most of our probates can be informal, where we don't have to have go before a judge and have that judge approval. But California, I understand what you're telling me. Every probate's more of a formal requirement, requiring these appearances.
For the full probate, yeah, you have to have the 2 appearances, both on the front side and the back side, and you know there's a lot of paper pushing in the middle.
Yeah.
But it's part of the process, and at the end of the day, you're in the state of California, so you do what needs to be done.
What do you say to people that say, well, wait a minute, my dad had a will, and you know, I thought the will avoided the probate process?
So that's a misconception that I hear often. If you have a will, in order to enforce the terms of that will, you actually have to admit it to the courts to approve it for probate.
Yeah.
And so the sheer essence of having a will means you're doing probate.
Yeah, you have to prove it. I think people in their minds think, well, Dad had a will. It says everything I get. They think that they can walk into the bank, show Mr. Banker, hey, here's the will. Dad's giving it to me. Turn this $100,000 account over to me. Mm-hmm. But you know, why would a banker be nervous about that?
They want to make sure that nobody else is going to make a claim on that account and be stuck in the middle.
That's right.
So they require what's called letters of personal representative, letters of administration, letters of testamentary, depending on the type of petition. But at the end of the day, they're going to require that piece of paper from the court that says this person has the authority to collect that asset of the decedent.
I've always used the statement that probate's kind of like a power of attorney for a deceased person. Do you see the similarities there? I mean, power of attorney gives somebody the authority to act for somebody that's disabled or incapacitated. Mm-hmm. Probate gives somebody the authority to act for somebody that's deceased.
I mean, I think that's a good comparison, just the only difference being that the process to get that authority is much greater in that probate administration than it is through just the presentation of a durable power of attorney.
Yeah. Thank you, Donnie, for your help today.
You're welcome.